Okay, let's unpack this. Welcome back to the deep dive. We're the place where we take some really dense source material, stuff you send us, and we try to break it all down, make it make sense. And today, wow, we are diving into something really serious. It's Texas Penal Code, Chapter 9. This is all about when using force, even deadly force, is legally justified. Like a complete defense if you're charged with a crime. So our mission here is to take this legal stuff, which can be super complicated, and make it clear, make it stick, so you understand where those legal lines are drawn. But hang on, before we jump into the deep end on this, it's a really important one. We just wanted to ask you, if you find this helpful, please subscribe to the channel. Seriously, your support, it's what helps us grow, helps us keep making these deep dives into tricky subjects like this one. And also check out the website. We'll have resources there, definitions, stuff related to this dive, and our past ones too.
Okay. And it's a fascinating area because we're talking about justification. It's right there in section 9.02. It's a core legal idea, really. It basically transforms an act that would normally be criminal into something excusable, something the law says is okay under the circumstances.
So it's not like asking for a lesser sentence or anything.
No, not at all. It's way beyond that. This is about establishing a defense that, if successful, means you're not criminally responsible, period. If your actions were justified, legally speaking, you didn't commit a crime. You're innocent in the eyes of the criminal law.
Wow. Okay, that's huge. So the definitions must be incredibly precise then. Section 9.01, right? That lays out the terms.
Absolutely critical.
Yeah.
And language has to be tight. And the big one, the one that carries so much weight, is deadly force.
Right. That's the high bar, the one everyone thinks about. But it seems like it covers more than just, actually killing someone.
It does. Significantly more. The law defines deadly force in a few ways. It's force the person intended to cause death or serious bodily injury, or force they knew would likely cause it. Or, and this is the kicker, force that, just in the way it's used or intended to be used, is capable of causing death or serious bodily injury.
Capable of it. Okay, so intent isn't the only factor. It's the potential harm. Like, if I swing a heavy pipe at someone's head, maybe I just want to knock them out, not kill them. But if they dodge it, that swing itself was still deadly force. Because the pipe could have killed them.
Exactly. That's precisely it. The potential for that catastrophic result is what pushes it into the deadly force category legally.
Got it. And you mentioned protected spaces. That's in 9.01 too.
Yes. Crucial for later sections, especially when we talk about presumptions. The law defines habitation, basically, a structure where people live. And that includes vehicles if they're adapted for living, like an RV.
Okay, habitation.
Vehicle. Pretty much anything used to transport people or property. Cars, trucks, boats, you name it.
So home and car, those get special treatment later.
They do. Keep those terms in mind. Habitation and vehicle. They unlock certain legal advantages we'll discuss.
Okay, so before we get into the specifics of, like, self-defense, there are some ground rules, general ideas that apply everywhere in this chapter.
That's right. Subchapters A and B lay out these foundational principles. They apply across the board, whether you're talking self-defense, defense of property, or even law enforcement actions.
Right, like the framework.
Exactly. And the first big one is about threats versus actual use, section 9.04. It says pretty clearly that threatening to use force is justified whenever using that force would be justified.
Okay, seems logical. If I can punch someone legally, I can warn them first. But what about weapons? That seems like a gray area. When does showing my gun stop being a justified threat and become, using deadly force itself?
That's the million-dollar question, isn't it? And the statute addresses it directly. Threatening deadly force, like pulling a knife, showing a gun, even saying, "I'll shoot if you come closer." That is not legally considered the use of deadly force. If, and this is the important part, your only purpose is to create the fear, the apprehension that you will use deadly force if you absolutely have to.
Okay, so it's about intent again, in a way. If I'm facing a real threat, maybe someone's charging me, and I draw my weapon and yell, "Stop."
Yeah.
That act of drawing and warning is just a threat under 9.04 because maybe using non-deadly force would have been justified at that point.
Correct. It's a justified threat.
It only becomes the use of deadly force if I actually fire the weapon.
Precisely. And then you need to meet the higher justification standard for using deadly force itself, which is in section 9.32. The law protects that warning shot, so to speak, or rather the warning display. It recognizes that sometimes showing you can use force is enough to stop things without anyone getting hurt.
Makes sense. Otherwise, why would anyone ever give a warning?
Exactly. Now, next up is confinement, section 9.03. This says if you're justified in using force, You're also justified in confining the person.
So if I can tackle someone attacking me, I can hold them down, restrain them.
Yes, generally. But there's a really important limit.
Okay, what's that? Because holding someone sounds like it could easily cross the line into, like, kidnapping or something if it goes on too long.
Right. And the law prevents that. The limit is you have to take reasonable steps to end the confinement as soon as you know you can do it safely. Unless, of course, the person has already been arrested by police. Then it's out of your hands.
So it has to be temporary, tied directly to the immediate danger?
Temporary and necessary. You hold the attacker down until the threat is gone, or until help arrives. The moment the immediate need ends, your justification to confine them ends too, unless they're under arrest.
Okay, that makes sense. The justification matches the necessity. It doesn't linger.
Correct.
Yeah.
Now, Section 9.05. This one's sobering, the innocent third-person problem.
Ugh. Yeah. This is where things get really complicated, right? What happens if I'm defending myself, completely justified against my attacker, but I accidentally hurt someone else, a bystander?
If you recklessly injure or kill an innocent third person while you're using force, even justifiably against your attacker, that justification defense, it's gone. It doesn't apply to the harm caused to the innocent person.
Recklessly. So not just accidentally, but specifically recklessly. What's the difference legally?
Recklessness means you are aware of a substantial and unjustifiable risk that your actions could harm someone else, but you consciously disregarded that risk. It's more than simple negligence or a pure accident. It implies a level of blameworthy disregard for the safety of others.
Okay, so let's walk through an example. Say I'm in a crowded place, maybe a parking lot at night. Someone pulls a knife, attacks me. I draw my firearm, I fire. Let's assume that's totally justified under 9.32 against the attacker. But it's dark, chaotic. I didn't check my background properly, didn't see an innocent person stepping out from behind a car, and my shot hits them.
In that scenario, your justification for defending yourself against the knife attacker likely holds up. You probably won't face criminal charges for that specific action.
Right.
However, because you acted recklessly by firing without confirming your backstop in a crowded, dark area, consciously disregarding the risks to others, you could absolutely be prosecuted for injuring or killing that innocent bystander.
Wow.
The justification for self-defense doesn't provide a shield for reckless collateral damage. The law demands you still exercise care for the public, even under extreme stress.
That's a huge responsibility, even when you're fighting for your life.
Okay,
Yes.
yes. Now, another critical point, Section 9.06. This draws a bright line between criminal law and civil law. Being justified under this chapter, under the Penal Code, it doesn't stop someone from suing you in civil court.
Right, this is huge.
Yeah.
So even if I'm found justified, maybe even acquitted in a criminal trial, the person I defended myself against, or their family, could still sue me for money.
Absolutely. They can sue for damages,
Yeah.
medical bills, lost wages, pain and suffering, wrongful death if applicable.
Why? If the criminal court said it was justified.
Because criminal court and civil court have different goals and different standards of proof. Criminal court needs proof beyond a reasonable doubt to convict. Civil court only needs a preponderance of the evidence, basically, more likely than not. So a jury could find it wasn't proven beyond a reasonable doubt that your actions were criminal, but still find it more likely than not that your actions were, say, negligent or excessive under civil standards, making you liable for damages.
So you can win the criminal case but still lose your house in the civil case.
That's the potential reality, yes. Criminal justification is not civil immunity. It's a crucial distinction for anyone relying on this chapter.
Okay, vital to understand. Finally, in this general section, there's necessity. Section 9.22. This sounds like the brink glass in case of emergency defense.
Sort of, yeah.
Yeah.
It's a defense for breaking a law when you reasonably believe doing so is immediately necessary to avoid some imminent greater harm.
Imminent greater harm. Okay.
Yeah.
And there are tests for this.
3 strict tests. First, that immediate necessity to avoid imminent harm. It can't be a maybe or something down the road. It has to be right now. Second, the harm you're trying to avoid must clearly outweigh the harm caused by breaking the law. The balance has to be obvious.
Can you give an example of that?
Yeah.
Clear outweighing.
Classic example. Breaking into an empty cabin in the mountains during a deadly blizzard to avoid freezing to death. The harm avoided death clearly outweighs the harm of minor trespassing and maybe breaking a window.
Right. But if you broke in just because you were a bit chilly.
It doesn't meet the test. The scales don't tip enough.
And the third test.
Third, there can't be a legislative purpose that plainly excludes the justification. Basically, if the legislature already thought about this specific situation and wrote a law saying don't do this, even in an emergency, then necessity doesn't apply.
Okay. So necessity is a backup defense, very specific circumstances, high bar.
Very high bar. It's not used lightly.
All right, now we're getting into the real core of it for most people, I think. Self-defense. Section 9.31 for regular force, and then 9.32 for the big one, deadly force.
Exactly. Let's start with 9.31, standard self-defense using non-deadly force. The basic rule is, force is justified when, and only to the degree, you reasonably believe it's immediately necessary.
Reasonably believe. Immediately necessary. Those seem to be the magic words again.
They are the absolute foundation. It's an objective standard. Would a reasonable person in your shoes have believed force was necessary right then, but viewed from your perspective at the time?
And it's to protect against the other person's use or attempted use of unlawful force.
Correct. You're reacting to an unlawful threat or action by someone else.
But like the general rules, there are times when force is specifically not justified, right? Section 9.31b lists these
Right.
tripwires.
That's a good way to put it. Hit one of these and your self-defense claim collapses. There's several key ones.
Okay, what's the first one?
Number 1, responding to verbal provocation alone. Someone insults you, curses at you, says horrible things. You cannot legally use physical force in response. Words alone are not unlawful force.
That's huge. So many fights start with words.
They do, but the law says you can't escalate it physically, just based on talk.
Okay, what's next?
Number 2, resisting arrest or search by someone you know is a peace officer, even if the arrest turns out to be unlawful later.
Wait, even if the cop is wrong?
Generally, yes.
Yeah.
You usually have to submit and challenge the arrest later in court. The exception is if the officer uses excessive force against you during that arrest or search, force beyond what's needed, that puts you in danger. Then you might be justified in using force to protect yourself from that excessive force. It's complicated.
Very tricky line. Okay, number 3.
Number 3,
Yeah.
if you consented to the force, like if you agreed to a boxing match, you can't claim self-defense when the other person punches you according to the rules.
Makes sense. Number 4, this is the one everyone talks about, right? Provocation.
Yes, the big one. If you provoke the other person's use of force against you, you generally lose your right to claim self-defense. You can't start the fight and then claim you were defending yourself when they fight back.
But there's an exception if you try to back out.
There is, but it's narrow. You lose the defense unless you completely abandon the encounter, clearly communicated you were backing down, and then the other person continued the attack anyway.
That sounds really hard to prove. Like, you have to show you clearly said, I'm done, I'm leaving, and they came after you anyway.
Extremely hard. The burden is on you to show you truly and effectively withdrew before they continued.
Wow. Okay. And there's a 5th one about weapons.
Yes. Section 9.31b5. You're not justified if you sought out the person you used force against while you were illegally carrying a weapon, like a prohibited knife, or illegally possessing a firearm.
So if you're already breaking a weapon law and that leads to the confrontation, no self-defense claim.
Generally, yes. It ties the justification to lawful conduct beforehand.
Okay, those are the big don'ts. But then there's this huge, the presumption of reasonableness in 9.31a. This sounds like a massive advantage for the defender.
It is. It's often called the castle doctrine element, though it applies beyond just the home. It flips the script legally. Normally, you'd have to convince a jury your belief that force was necessary was reasonable. Under this presumption, the law assumes your belief was reasonable.
Assumes it. Automatically.
Yes, if certain conditions are met. The prosecution then has the burden to prove your belief was unreasonable, which is much harder for them.
Okay, what are those magic conditions?
Condition 1 relates to place and action. It applies if the person you used force against was unlawfully and forcefully entering or attempting to enter your occupied habitation, vehicle, or place of business employment.
Habitation, vehicle, and workplace. Okay, those specific spots.
Or if they were unlawfully and forcefully trying to remove you from one of those places.
Or if they were committing or attempting one of those really serious felonies.
Yeah. Exactly. The list is aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery.
Yeah.
If someone is doing any of those things or breaking into your occupied home, car, or workplace, your belief that you needed to use force is presumed reasonable.
Presumed reasonable, that's powerful. But there's still caveats, right? It's not automatic even then.
Correct. 2 crucial caveats, tying back to the limitations we just discussed. The presumption applies only if you, the actor, did not provoke the person.
Right, no starting the fight.
And only if you were not engaged in criminal activity yourself at the time. other than a minor Class C traffic ticket like speeding.
Right.
You have to be the innocent party in that moment.
Okay, so in your home, car, or workplace, facing an unlawful intruder or one of those serious crimes, and you didn't start it and weren't breaking the law. The law is basically on your side regarding the reasonableness of using force.
That's a good summary. And it gets even stronger when combined with the no duty to retreat rule, sections 9.31E and F.
Ah, stand your ground. That's
Yeah.
what people call it, yeah.
That's the common term, yes. The law states that if you have a right to be where you are, you didn't provoke the attack, and you're not engaged in crime. You are not required to retreat before using force.
So if someone attacks me on the street where I have a right to be and I didn't start it, I don't have to try and run away first?
Correct. You don't have a legal duty to retreat in that situation under Texas law. But it goes further.
How so?
Section 9.31F explicitly tells the jury or judge deciding the case. They cannot consider whether you failed to retreat when they're deciding if your use of force was reasonable.
Wow. So the prosecution can't even argue, well, they should have just run away.
Nope. That argument is legally off the table if the conditions for no duty to retreat are met. It reinforces your right to defend yourself right where you stand.
That's a very strong protection for self-defense.
Yeah.
Okay, so that's non-deadly force. What happens when the situation escalates? When does the law allow deadly force under Section 9.32?
Okay, deadly force. The absolute highest level, it requires meeting two main conditions.
Condition 1.
Condition 1. You must have been justified in using non-deadly force under Section 9.31 in the first place. All those rules we just talked about, no provocation, no illegal activity, immediate necessity, they all still have to apply.
So 9.31 is the foundation. You need that first.
Absolutely. If you weren't justified under 9.31, you can't possibly be justified under 9.32.
Okay. And Condition 2, the extra requirement for deadly force.
Condition 2, you have to reasonably believe that deadly force specifically is immediately necessary for one of two reasons. Reason A, to protect yourself against the other person's use or attempted use of unlawful deadly force.
Yeah.
Tit for tat, essentially. They use deadly force, you can respond with deadly force.
Makes sense. Life for life threat. What's reason B?
Reason B, to prevent the other person's imminent commission of one of those specific severe felonies. Aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery.
Ah, that list again. So deadly force isn't just about stopping deadly force. It's also about stopping these specific, incredibly violent crimes, even if the criminal hasn't explicitly threatened your life yet.
Correct. The law recognizes that those specific crimes carry such an inherent, immediate risk of death or serious bodily injury that deadly force may be necessary to stop them before they are completed or escalate further.
So if someone is, say, committing an aggravated robbery against me using or exhibiting a deadly weapon while stealing the law says I might be justified in using deadly force to stop them because the robbery itself is such a dangerous situation.
Exactly. The imminent threat posed by the commission of that specific type of felony can justify a deadly force response, provided you reasonably believe it's immediately necessary.
And does that presumption of reasonableness, the Castle Doctrine idea, apply to deadly force too in my home, car, or workplace?
Yes, it does. Section 9.32b mirrors the presumption in 9.31a. If someone is unlawfully and forcefully entering your occupied habitation, vehicle, or workplace, or trying to remove you or committing one of those listed felonies, your belief that deadly force was immediately necessary is also presumed reasonable, again, provided you didn't provoke and weren't engaged in crime.
And the no duty to retreat, does that apply when using deadly force?
Yes. Sections 9.32c and d extend the no duty to retreat rule explicitly to deadly force situations under the same conditions. Right to be there, didn't provoke, not breaking the law.
So the core protections presumption of reasonableness in certain places, no duty to retreat, they hold steady whether you use force or deadly force as long as the underlying conditions are met.
That's the structure, yes. Consistency in those core principles.
Okay. What about defending someone else? If I see someone being attacked, Section 9.33, defense of a third person.
This uses the stand in their shoes principle.
Yeah.
You can use force or even deadly force to protect a third person if you reasonably believe two things.
What are they?
First, you have to reasonably believe that the third person would have been justified in using that same level of force themselves under Section 9.31 or 9.32.
So I have to assess if they have the right to self-defense.
Basically, yes. You
Yeah.
step into their legal shoes. If they provoked the fight, for example, then they wouldn't be justified, and therefore you wouldn't be justified in defending them with force.
Okay. And the second belief?
Second, you have to reasonably believe that your intervention is immediately necessary to protect that third person. You can't jump in after the fact or if they don't actually need help right then.
So it requires a quick, accurate assessment of the whole situation, including whether the person you're saving is actually the victim.
It does. Good intentions aren't enough if the person you defend was actually the aggressor or wasn't legally justified themselves.
Tricky. Okay, last one in this section. Section 9.34, protection of life or health. This is about preventing suicide or self-harm.
Yes. The law allows you to use non-deadly force when you reasonably believe it's necessary to prevent someone else from committing suicide or inflicting serious bodily injury on themselves.
Just non-deadly force, like tackling someone about to jump?
Exactly. But the rule for deadly force here is incredibly narrow.
How narrow?
Deadly force is justified under this section only when it's immediately necessary to preserve the other person's life in an emergency.
Preserve their life. Using deadly force. That sounds contradictory. What's an example?
It's very rare. Think of a truly desperate medical emergency, where maybe administering a life-saving drug requires an action that carries a risk of death itself. But it's the only possible way to save their life right now, and there's no time for trained medical personnel. It's an extreme last resort justification focused solely on preserving life in dire straits.
Okay. Extremely limited. Got it.
Yeah.
All right, moving on to protecting property, subchapter D. Now, my understanding is the rules here are generally a lot stricter than protecting a person.
Much stricter, yes. Human life and safety are valued more highly than property under the law, and the rules reflect that.
So, section 9.41 is about protecting your own property using non-deadly force. What does that cover?
It allows you to use reasonable non-deadly force when you believe it's immediately necessary to prevent or stop someone from trespassing on your land or unlawfully interfering with your tangible, movable property.
Tangible, movable property. So, my stuff, my car, my tools, my wallet.
Exactly. Stuff you can touch and move, and also your land. You can use reasonable force to stop someone from tagging your fence or trying to steal your bike or kicking them off your front porch if they're trespassing.
What about getting property back after it's already been taken?
That's where the fresh pursuit rule comes in.
Yeah.
You can use non-deadly force to recover property that's just been unlawfully taken from you.
Yeah.
But only if you do it immediately after the dispossession or in fresh pursuit right afterward.
So I have to act fast. I can chase the guy who just snatched my phone.
Yes. Provided you reasonably believe they don't have a legal claim to it and they took it using force, threat, or fraud. You can't wait an hour, track them down, and then start a fight. It has to be immediate or a continuous chase. The law wants to avoid delayed vigilante justice over property.
Okay. Non-deadly force for immediate defense or recovery.
Yeah.
The really complex one, section 9.42, deadly force to protect property. This sounds like it's almost never allowed.
It's extremely restricted. Using deadly force just to protect property is very difficult to justify legally. It requires meeting 3 layers of conditions simultaneously.
3 layers. Okay, layer 1.
Layer 1, you must have been justified in using non-deadly force under 9.41 in the first place. Same foundation as deadly force for self-defense.
Got it. You needed the right to use some force. Layer 2.
Layer 2 specifies the very limited circumstances. You have to reasonably believe deadly force is immediately necessary for one of 2 reasons. Reason A, to prevent the imminent commission of certain specific serious crimes against your property. The list is arson, burglary, robbery, aggravated robbery, and crucially, theft during the nighttime or criminal mischief during the nighttime.
Nighttime. Okay, let's pause there. Why the distinction? Why is theft at night treated differently than theft during the day for using deadly force?
That's a really important point. The law seems to operate on the assumption that crimes committed under the cover of darkness inherently pose a greater, more immediate threat of violence to people.
Because you can't see as well, the criminal might be more desperate, more likely to be armed or react violently if confronted.
Exactly. There's a higher perceived risk of the property crime escalating into a violent confrontation at night. So the law provides this very narrow justification for deadly force against certain crimes only when they happen at night. Daytime theft or mischief doesn't qualify under this part.
Okay. Arson, burglary, robbery, aggravated robbery, anytime. But theft and criminal mischief only at night. What's the other reason under layer 2?
Reason B, to prevent someone who has just committed burglary, robbery, aggravated robbery, or theft during the nighttime from escaping with the property.
So stopping the getaway after one of those specific crimes, including nighttime theft.
Yes, but again, only immediately after and only for those crimes.
Okay, that's layer 1 and 2. That already seems really narrow. What's the third layer? The real failsafe, you called it, section 9.423.
This is the crucial hurdle. Even if layer 1 and 2 are met, you also have to reasonably believe one of two additional things is true. Either A, the land or property cannot be protected or recovered by any other means, like calling the police, shouting, using a lesser force. None of that would work.
No other means at all.
Or B, using force other than deadly force would expose you, or someone else, to a substantial risk of death or serious bodily injury.
Okay, let's test this. My house, 3 a.m. I see someone in my detached garage trying to steal my expensive tools. That's burglary, maybe theft during the nighttime. Layers 1 and 2 seem met. But layer 3, can I use deadly force? What if I could just call 911? Or yell from the house? Would those count as other means?
Absolutely they would. If calling the police was a viable option, or if you could safely scare them off without exposing yourself to danger, then deadly force likely wasn't justified because other means existed to protect the property.
So unless the burglar is actively coming towards the house, threatening me or my family, or maybe setting the garage on fire, arson, just stealing the tools probably doesn't meet layer 3.
It's very unlikely to meet layer 3 in most scenarios. The law heavily restricts deadly force solely for property. It usually requires that additional element of personal danger or proof that deadly force was literally the only conceivable way to stop one of those specific serious nighttime crimes or arson, burglary, or robbery.
Wow. Okay. Extremely high bar for deadly force on property alone. What about protecting someone else's property? Section 9.43.
Similar rules, but with an added relationship requirement. You can use force, or even the very limited deadly force under 9.42, to protect a third person's property if you would have been justified protecting your own, and one more condition is met.
Which is?
Either you reasonably believe the interference is theft or criminal mischief, or the third person asks for your help, or you have a legal duty, like a security card, or the property belongs to your spouse, parent, child, someone living with you, or someone under your care.
So you need some connection. Either they asked, it's your job, or they're close family household members. You can't just intervene with force in a random property dispute down the street.
Generally, no. The law limits intervention to situations where you have a clearer stake or responsibility.
Okay. Lastly, Section 9.44, use of devices. This is about, fences or alarms or booby traps.
Right. It justifies using a device to protect land or property, but only if two conditions are met. One, the device is not designed to cause or known to create a substantial risk of causing death or serious bodily injury.
So no spring guns, no electrified death fences.
Absolutely not. Lethal booby traps are illegal and unjustified. Think more like standard security fences, maybe barbed wire in some contexts, alarms, motion lights.
And the second condition?
The use of the device has to be reasonable under all the circumstances when you set it up. A simple fence is usually reasonable. An unusually dangerous configuration might not be. It bans lethal traps and requires reasonableness for everything else.
Okay, now we shift gears to official actors, law enforcement, security personnel. Section 9.51, arrest and search. How does justification work for police officers?
Well, officers operate under different rules because they have a duty to act. A peace officer is justified in using force when they reasonably believe it's necessary to make an arrest, conduct a search, or prevent someone from escaping after arrest. A key point here is the officer must also reasonably believe the arrest or search itself is lawful, or that the warrant they're using is valid.
Even if the warrant later turns out to be flawed?
Yes. If the officer's belief in its validity was reasonable at the time, their use of necessary force might still be justified. They also generally need to announce who they are and why they're there, unless it's obvious or unsafe impossible to do so.
And when can an officer use deadly force during an arrest or to prevent escape? Section 9.51c.
Again, stricter rules. Deadly force is only justified if regular force was justified and one of two conditions exists. Condition A, the specific crime the person is being arrested for involved the use or attempted use of deadly force itself. Basically, they're arresting a dangerous, violent felon.
Okay. Condition B.
Condition B. The officer reasonably believes there's a substantial risk that the person will cause death or serious bodily injury to someone if their arrest is delayed.
Substantial risk. That sounds like it requires more than just a hunch. What kind of things would show substantial risk?
It needs concrete facts. Maybe the person is actively shooting or just committed a violent assault and is fleeing towards bystanders while still armed, or making credible threats to kill officers or others if apprehended. It has to be an articulable, immediate danger justifying the extreme measure of deadly force to stop them now.
And Like citizens, officers have no duty to retreat either, right? 9.51E.
Correct. The statute explicitly states officers have no duty to retreat before using force in these situations.
Okay. What about preventing escape from custody after an arrest? Section 9.52. Is it the same standard?
Generally, the force used to prevent escape from custody, like from the back of a police car, is limited to the force that would have been justified to make the initial arrest. However, there's a major exception for correctional facilities.
Ah, prisons and jails.
Right. A guard employed by a correctional facility or a peace officer working there is justified in using any force necessary, including deadly force, if they reasonably believe it's immediately necessary to prevent an escape from the correctional facility itself.
Any force. That's broad. Why the difference?
The rationale is the extreme danger posed to the public by someone escaping from a secure prison or jail environment. Maintaining the security of the facility is paramount, so the law grants broader authority, including deadly force, to prevent escapes from the institution.
And Section 9.53 reinforces that for just general security inside the facility, too.
Yes, it allows officers and employees in correctional facilities to use force reasonably necessary to maintain security, order, and the safety of staff and inmates within the walls.
Okay, now this is where it gets really modern. Section 9.54, use of force by drone. This is new stuff, right? Addressing technology.
Very new, yes. Added recently and reflects the changing landscape of law enforcement tools, it places significant limits on using drones to apply force.
Why specifically regulate drones? What are the big restrictions?
Well, the potential for misuse, the detachment, the lack of immediate human presence. It raises concerns. So, the law says drone force is justified only if several conditions are met. First, the person operating it must be law enforcement. Second, the use of force itself would have been justified under other rules if done by a person directly. Third, and this is absolutely critical, the justification does not apply to the use of deadly force by means of an autonomous drone.
Autonomous drone, meaning a drone that makes the decision to shoot by itself, AI-driven.
Exactly. The law explicitly forbids justifying deadly force deployed by an autonomous system. There must be a human operator making that ultimate lethal decision if a drone is involved. Remote piloting might be allowed under strict rules, but AI killing is out.
That's a major ethical line drawn in the sand. Any other requirements for drone force?
Yes. The law enforcement agency must have adopted a specific detailed policy on using drones for force, submitted it to the state, and the specific use of the drone must follow that policy precisely. It adds layers of administrative control.
Okay. And then Section 9.55, also very new, about less lethal force weapons. What does this cover?
This addresses things like tasers, stun guns, pepper spray, chemical devices, batons, striking devices, tools designed to incapacitate with a lower risk of serious injury.
And who can use these under this justification?
It applies only to guards, like in correctional facilities, or peace officers acting in their official duties.
And the standard?
The use of the less lethal weapon is justified when it's reasonably necessary to accomplish their official duties, and this is key. The way they use it is in substantial compliance with their training on that specific weapon.
Ah, so justification is linked to proper training and use. You can't just misuse a taser and expect to be covered.
Exactly. It ties the legal protection to professional standards and departmental policy for these specific tools.
Okay, last section. Subchapter F. This covers situations where justification comes not from self-defense or police duty, but from a specific role someone has, like a parent or teacher.
That's right. These are relationships where one person has care or responsibility for another. And the absolute key rule across this entire subchapter, only non-deadly force is justified. Never deadly force.
Never deadly force. Got it. So, Section 9.61, parent-child, who does this apply to?
It applies to a parent, a step-parent, or anyone acting in loco parentis.
In loco parentis, what does that mean practically?
It means in the place of a parent. So legal guardians, grandparents who have custody, maybe even a temporary caretaker like a babysitter if they have the parent's authority.
Okay. And when can they use force?
When they reasonably believe the force is necessary to discipline the child or to safeguard or promote the child's welfare, and this applies only to children under 18.
Discipline or safeguard welfare. This sounds like the legal basis for, say, spanking or physically stopping a kid from running into the street.
Yes, that's the intent. However, this is a very, very fine line legally. The force must be reasonable and necessary.
Reasonable. How is that judged? Because one person's discipline is another's abuse.
Exactly. The law looks at the age and size of the child, the nature of the misbehavior, the type of force used, whether it caused injury beyond temporary pain. If the force is excessive, cruel, or causes actual injury, it crosses the line into assault or child abuse, and the justification defense disappears entirely. It's strictly limited to moderate corrective force.
A very difficult line. Okay, section 9.62, educator-student, similar idea.
Similar structure. It applies to educators or anyone entrusted with care, supervision, or administration for a special purpose. Think teachers, principals, coaches, maybe camp counselors.
And their justification.
They can use reasonable, non-deadly force when necessary to further that special purpose, like education or safety, or to maintain discipline in a group.
So breaking up a fight between students, removing a disruptive student from class so others can learn.
Yes, those are classic examples. Physically intervening to maintain safety or order necessary for the educational environment. Again, only reasonable, non-deadly force is allowed.
And the last one, section 9.63, guardian-incompetent.
This applies to a legal guardian, or someone similarly responsible for the care of a person who is mentally incompetent. They can use reasonable, non-deadly force, when necessary, to safeguard and promote the incompetent person's welfare, or, if the person is in an institution, to maintain discipline there.
So maybe physically restraining someone who is mentally incompetent from harming themselves or others in a facility?
Exactly. Because the person may not understand risks or rules, some level of physical management might be necessary for their safety or the safety of others. But always, only reasonable, non-deadly force related to care and safety. The theme across all three is protection and guidance, not punishment through excessive force. Hashtag tag outro. So if we're going to zoom out and look at this whole Chapter 9, what we see is that justification is incredibly specific. It's conditional and nearly always comes back to that reasonable belief of immediate necessity. And the context matters hugely. Are you defending yourself, your home, property at night? Are you an officer, a parent? Each situation has its own detailed rules. The law demands proportionality. It demands necessity. And it puts very strict limits, especially when innocent people might be harmed or when only property is at stake.
Yeah, the big takeaways for you, the listener, I think are really those key pillars we hit. First, know the difference between simple force under 9.31 and deadly force under 9.32, and the much higher bar for deadly force. Second, understand that powerful presumption of reasonableness and the no duty to retreat rule, especially in your habitation, vehicle, or workplace, but remember, only if you're the innocent party. And third, never forget that even if you're criminally justified, you might still face a civil lawsuit. Section 9.06. That criminal shield doesn't automatically block a civil claim.
Absolutely. Understanding those distinctions, those conditions, it highlights the huge responsibility the law puts on anyone who chooses to use force. And maybe a final thought to leave you with, something to chew on. Considering how strict the law is about recklessly harming innocent third parties, Section 9.05, and how it demands you prove there were no other means to protect property with deadly force under 9.42, how does that constant legal pressure for immediate necessity and considering alternatives shape the split-second decisions people have to make? Citizens, officers, everyone operating under this code. It forces a kind of rapid, high-stakes calculation of risk, options, and justification, even when survival instincts are screaming. It shows the law expects rational thought even in the most irrational moments. Something to think about based on everything we've unpacked today.
Definitely something to think about. A huge thanks for walking us through that complex chapter, and thank you, the listener, for joining us on the deep dive. We'll catch you next time.